Let's take a look at a key case in tort law for vicarious liability. This case is Barclays Bank PLC versus various claimants, which was heard in 2020. In this case, the defendant was Barclays Bank, and there was 126 parties who were all the claimants. The facts of this case are that a qualified doctor called Dr. Bates conducted medical examinations for Barclays Bank in respect of prospective and current employees. He then received a fee per examination. A group of 126 female claimants made allegations of serious sexual assault against the doctor taking place during the medical examinations. These examinations were a condition of employment for the claimants, and the claimants were made to undertake the examination alone. The doctor was provided with a proforma by the bank, headed with the bank's logo and entitled Barclays Confidential Medical Report. The report was completed and signed by the doctor and the claimant and was then returned directly to the bank. Dr. Bates also had various other roles working for the NHS, a portfolio of private clients, and writing articles for a weekly newspaper. His work for the bank was a very small proportion of his work. He had autonomy in his decision-making and could refuse to do an examination if he chose. He had his own medical liability insurance, although it may not have covered intentional torts such as this. The case concerned whether the bank was vicariously liable for the actions of the doctor. The bank sought to prove that there was no relationship of employment and the doctor was therefore self-employed. The Court of Appeal had previously decided that Barclays could be vicariously liable for the actions of an independent contractor. However, the Supreme Court disagreed with this decision and unanimously agreed that Dr. Bates was not an employee but was an independent contractor, and therefore there was not a relationship akin to employment. Barclays were therefore not vicariously liable for his actions. This effectively confirmed that there is an independent contractor defence in vicarious liability, which can be effective in deciding employment status. This can be used in your essays where there is a situation in a scenario that is not clearly an employee-employer relationship, but the relationship may be akin to employment. This means that their relationship could be like one of employment, and therefore there could be liability on the part of the defendant. However, if you decide based on the facts that the relationship is not akin to employment, such as in the case of Barclays, then you would need to argue that there would not be liability and the claim would fail. To make this decision about whether there is a relationship akin to employment, you would need to look at the facts of the case. Lady Hale in this case stated that although Dr. Bates was a part-time employee of the health service, he was not at any time an employee of the bank, nor viewed objectively was he anything close to an employee. The outcome of this case would have been different if Dr. Bates had been made to accept referrals as part of his position, but this was not the case as he was allowed to refuse examinations. He also had other clients and was therefore operating business on his own terms.